Thank you. Good evening. I'm Cynthia Elliott, President of the Rochester Board of Education. We are having a work session tonight. Tonight is October 6th, I believe the date is, talking about long-term suspension, short-term suspension, the entire suspension process. And the reason that I wanted us to have a work session on suspensions really had to do with how the process works. By the time some of the appeals get to the board level, the suspension date has been passed. And so the board really needed to understand how appeals work, what that process is from beginning to end, so that the board can make a better decision, and if there needs to be some policy changes, that we can make those policy changes. And so I'm going to turn it over to the superintendent to begin the presentation for us. And I'm hoping that our audience really is listening in on how this suspension process works. We've had, over the years, thousands of suspensions. And I remember when I first campaigned, there were, I believe, 14,000 suspensions that we had in the district. And I really campaigned on that we reduce that. And what we found in that is that many of the students that were getting suspended were middle school students, 7th, 8th graders, some 9th graders, but mostly 7th, 8th graders who are trying to learn how to be men and women. But we as a district have not really been able to provide the kind of support that they need. Consequently, a lot of the suspensions. And so we're looking at, having a different grade configuration where we really can focus in on that particular population so that we can reduce the suspensions. And so I'm going to turn it over to Interim Superintendent Dr. Carmine Peluso. Dr. Peluso?
Thank you, President Elliott, and good evening, Board Commissioners, families, students, staff joining us on Facebook Live and YouTube. So just like President Elliott has outlined, today we're really going to talk about process and procedures regarding suspensions. We will not be getting into causes, data at this point in time. That may be a work session for another time, but really today is about understanding the process, the rights our families have, and the rights our students have when going through a suspension process. So, for today, we will be looking at our short-term suspension process, a long-term suspension process, how you appeal a long-term suspension and what that looks like. After a long-term suspension, what does placement look like? Where do students go? What does placement look like? And then returning back to school, re-entry back from suspension, long-term suspensions, and the process from there. So when we talk first, the first level of really any sort of removal is a removal from a classroom. And this is actually a right a teacher has to remove a student from a classroom that poses a substantial disruption. So the teacher has the power to remove a student from a classroom if there's some worry about safety, if there's disruption, they have the right to do that. And when that's done, they have to complete some notification to the principal, and the principal must explain to the student why that has happened. And then the student is always given the opportunity to present their side, and then the teacher once again completes the teacher removal form. Principal has to inform the parent, always a request and potential for an informal conference. And then in this case, from the removal from the classroom, the principal is the final decision maker in terms of if that student is removed from the class or not. Our next, after removal from a classroom, is a short-term suspension. And a short-term suspension is a 5-day or less suspension. By law, a principal has the authority to suspend a student for up to 5 days. Anything longer than 5 days would go to a long-term suspension hearing, which Council Neal will be talking about later on in the presentation. But when they suspend for 5 days or less, it does have to be aligned with our board-approved code of conduct. So they cannot just suspend for the sake of suspending. It has to be aligned and in conjunction with our board-approved code of conduct. Once again, a principal must give notice of the charge of misconduct, what has happened, what the student is being charged with, and then must provide the opportunity for the student to present their side as well. Again, right, the student's version of events, what has happened, needs to be taken into consideration. Once again, a parent has a right for an informal conference upon receiving notification of the suspension. Principal, once again, makes in a short-term suspension up to 5 days, makes the final determination of what it is. A school during that time needs to provide equivalent instruction, substantially equivalent instruction, and then a parent may appeal in a short-term suspension of 5 days or less to the Commissioner of Education if they so choose. Different than a long-term suspension where they're appealing to the Board of Education. In this case, on a short-term suspension, they're appealing to the Commissioner of Education. And then just so there's two types of short-term suspensions. Once again, 5 days or less. They could be, depending on the nature, an in-school suspension where the student is in school, in an in-school suspension room or something along those sorts for up to 5 days. And then there's the out-of-school suspension and a short-term suspension. So up to 5 days. That the reason is that the student possesses a danger to the property, a threat, or a disruption to the academic process that would be outside of school for 5 days. And once we hit more than 5 days, that's when we transition to a long-term hearing, a long-term suspension process that I'm going to have Council Neal take us through.
Hi, good afternoon. I apologize. I'm having some technical difficulties. Let me know if everyone can hear and see me.
Yes, we can see you.
Okay, thank you.
So we can't see you.
We can hear you.
Okay, well, I apologize about that. I am trying to get the camera on, but in the interest of keep the process moving, I will present without the camera, if that's okay.
Sure.
Yeah. One, I want to give a general overview of the long-term suspension process, and long-term suspensions are those suspensions that are more than 5 days. And I do have to give a bit of a disclaimer. Again, this is not legal advice. For view public, this is just general information about the district's processes and procedures. So once an event occurs that is contrary to our code of conduct and that has been witnessed or documented by the principal, and an investigation has been conducted, the principal referring a student for a long-term suspension must ensure that the following things have been established. First, that the student's conduct meets the standards established in a code of conduct for a long-term suspension. Or suspension should always go back to our code of conduct. The principal should consult with the appropriate school chief regarding long-term suspension. The chief will double check whether the matter falls under long-term suspension in the code. And then there should also be a check of whether meaningful interventions have been faithfully employed for each category of the offense. All right. If you look at the code of conduct, you'll see that there's interventions, and a student shouldn't be long-term suspended until you're in that particular tier. So there should be a check that meaningful interventions have been faithfully employed for each category of offense, that they have been documented, and that they have been unsuccessful in averting the behavior. In addition to that, long-term suspension should not take effect until really three things: an investigation, notice, and a hearing. And I'm going to go through those in sequence. So when a student engages in conduct for which a long-term suspension may be warranted, the principal must do a thorough investigation. It is the responsibility of the principal or his designee to take the following investigative steps. First, you want to question the victim and any other witnesses to the incident whenever possible and whenever possible obtain signed written statements. The investigative procedure should seek to understand the entirety of the events, including, what precipitated the precipitating factors. There should be review and retention and reasonable time there should be review and retention of any documentary, photographic, or video evidence. Whenever possible, the principal should inform the accused student of the misconduct for which he or her is being accused and provide the accused student with an explanation of the evidence. Whenever practicable, you should provide the accused student an opportunity to present his or her side of the event and to identify any witnesses that the student believes are important. In circumstances where a student has been arrested, the student should be advised that any statement made by the student may be used against the student in a court of law, and that the student's parents should be notified immediately. The principal should take into account all the factors identified under the levels of intervention and disciplinary responses when making a recommendation about a disciplinary action. The second key component is notice to the parents. Schools have to provide notice when a long-term suspension or expulsion is proposed. The principal should make every effort to reach the parent by telephone, email, or any other electronic means to inform the parent of the student's referral for long-term suspension on the same day as the determination to seek the suspension. Written notice has to be delivered to the parent within one school day from the termination to seek the suspension. The written notice should be in the parent's dominant language if practicable. And that notice should include the following things: a description of the incident, including the specific section of the code of conduct that the student allegedly violated, the exact length of the proposed suspension, a statement explaining the standard positive interventions and practices that were used, or if none were used, explain why that's the case, and explaining why the use of alternative exclusion or discipline may be justified under circumstances. A statement of the students' and parents' rights written in plain language, including a right to a fair hearing, the right to question the district's witnesses, and to present testimony and other evidence on behalf of the student. The right to obtain school records, the right to bring an attorney or an advocate to the hearing, the right to interpretation of the hearing by a qualified interpreter or someone of the parents' choosing, and of course, as Superintendent Peluso indicated, the right to appeal. It should also give a description of the alternative education that would provide it to the student until the time that a determination has been made with respect to whether the student is guilty of the charge and any applicable penalty that has been imposed. The long-term suspension office shall also send notice to the parent and includes a date and time and location for the fact-finding hearing, a statement that if the child has been arrested or if a criminal investigation is pending, that any statement, written or oral, can be used against the student in a court of law, and a list of free and low-cost attorneys and advocates in the area, and the procedures for appealing the disciplinary decision. The final key component of the long-term suspension process that I'm going to cover is the hearing. And the hearing is an opportunity for an impartial and neutral hearing officer to determine if the school can meet its burden of proof to sustain the charges. And if the proposed suspension or expulsion is appropriate, the hearing should occur within 5 school days of the date of suspension, unless the parent requests a later date. If the hearing occurs after the 5th day following the suspension without the parent's consent to the delay, then the student should be returned to his regular program until the hearing is held and the superintendent or designee has made a decision regarding the charges. I am going to go into some elements of what the hearing itself entails. So hearing should be conducted, one, by a neutral and impartial hearing officer. Upon that appointment, the hearing officers are authorized to administer oaths, to issue subpoenas in conjunction with the proceeding before him or her. the school must provide the alleged student, the school must prove, I should say, the alleged violation by competent and substantial evidence. The schools cannot rely on exclusively on hearsay evidence to meet their burden of proof. Students and parents have the right to call witnesses and to present documentary evidence, including but not limited to witness statements, incident reports, audio and video recordings, and to question persons with information related to the incident. Students and parents have the right to request, and upon request, the district must require the presence and testimony of witnesses who are school employees. Students and parents have the right to request the presence and testimony of witnesses who are safety or law enforcement personnel, and the school shall take all reasonable steps to ensure their presence. Students and parents have the right to request the presence and testimony of other students or witnesses to the event, and the school shall take all reasonable steps to ensure their presence as well. And students and parents have the right, to representation by an attorney or by an advocate. The hearing officer shall consider only evidence presented at hearing and should make findings of fact and recommendations to the superintendent or his designee as to what the appropriate measure of discipline is. The proposed suspension can be dismissed, reduced, or upheld. There's some guidelines for how the hearing officer should rule in a long-term suspension. So the hearing officer should dismiss the proposed suspension if he or she determines that the suspension was imposed for behavior which is prohibited, for which suspension is prohibited under the code of conduct. The hearing officer should also dismiss if the school did not present sufficient evidence to meet its burden of proof. And the hearing officer should also dismiss if the suspension was not appropriate, considering the factors listed in the code of conduct. The hearing officer or superintendent may dismiss or remove if he or she determines that the school did not impose the graduated or proportionate discipline, unless the conduct that resulted in the suspension was sufficiently serious that graduated discipline would not have been appropriate. The hearing officer may dismiss or remove if the suspension was not appropriate given the facts as presented at hearing, and the hearing officer may dismiss or remove or reduce if the school did not follow due process procedures. Upon request of the parent, the district should provide interpretation services. I believe we already covered some of that. Students and parents have the right to receive written notification of the determination of guilt or lack thereof and penalty if guilt is determined. If the superintendent or his designee determines that a long-term suspension or expulsion is warranted, then a written decision should include the length of suspension, the conduct for which the student has been found guilty, and procedures for appealing decision, including the date by which the appeal must be submitted. The written decision shall be sent to the student and parent within 3 school days after the superintendent designee receives the penalty determination. And we are required to keep an accurate and complete record of the hearing, but we're not required to keep stenographic records, and we're not required to keep audio and video recordings. Students and parents shall have the right to receive request and receive a copy of the record. There's one final element as it pertains to hearings that I want to go over, and that involves students with disabilities. So for students with disabilities, which include students with IEPs, students with declassification services, students with 504 plans, and students presumed to have a disability, manifestation determination must be completed in order to ensure that no student is recommended for long-term suspension who has engaged in behavior which is a manifestation of his or her disability. Only in the event that a finding of guilt is made at the fact-finding hearing, and the suspension recommendation may result in more than 10 days of removal in the current school year, will a manifestation determination review be conducted by the Committee on Special Education for cases, and again, this is for cases where students have an IEP 504 plan, or for cases where a student is presumed to have a disability. If the CSC determines a manifestation has been found, the student is not suspended unless it is a matter involving weapons, serious bodily injury, or illegal drugs. If no manifestation is found, then the student may be referred back to the long-term suspension office for penalty. If, however, the behavior is determined to be due to the student's disability, the student will return to the school and the district must conduct what's called a functional behavioral assessment, or FBA, and implement a behavioral intervention plan, BIP, unless the student is removed to an interim alternative education setting by the student, the superintendent, or New York State Department of Education impartial hearing officer for weapons, serious bodily injury, and illegal drugs. Even if a student is already in an alternative setting, if the behavior complained of is found to be a manifestation, the student must be returned to regular program of study, regardless of whether he or she has been placed in that alternative setting. If the student is returned to school because a manifestation was found, there is technically no suspension, and the student's attendance record should be amended for the time spent out of school, and that should be changed to absent or excused. And again, for those students involved in weapons, serious bodily injury, or drug possession, the long-term suspension referral can proceed regardless of the outcome of the manifestation determination. So those were the areas that I had to cover related to long-term suspensions. And with that, I will turn it over to, I believe, Charisma Travis for a little presentation on the appeals process.
Thanks, Adrian. So good evening. So in regards to board involvement in appeals, so once the student is long-term suspended and they receive their notice from the superintendent, they do have the right to appeal. And so students who receive a long-term suspension may submit an appeal to the board. And when we say may submit, we're talking about whether there's a student or parent or guardian. Either one of them are able to submit the paperwork to the board to appeal. Appealing means you disagree with the superintendent's long-term suspension decision and would like to take your case to a higher level for reconsideration. Students and families should submit an appeal if they believe there was a problem with the hearing or if the student's rights were violated. So for example, due process would be an example of the student's rights being violated. Families may appeal within the appropriate timeline, even if the suspension has expired. And so as of right now, families have 30 school days to be able to submit an appeal to the board. And this covers any long-term suspension. Doesn't matter how egregious it is, what the violation was, but they have the right to appeal as long as they are within that 30 school day time period. And I want to just re-emphasize that 30 school day period, because I know the board has received questions from families about when they appeal within 30 days. There's a difference between 30 days, 30 calendar days, and 30 school days. And so while the appeal is being determined within the 30 school days, what will happen is that when the board meets to review the appeal, they are reviewing the long-term suspension packet that they receive, the hearing record, so that would be the video and or audio from the hearing, evidence submitted at the hearing, and then I just want to add on to this that it's very, very important that students and their parent or guardian attend these hearings, because when you submit an appeal to the board, the student or their parent or guardian, they're not part of that appeal process. And so whatever your reasoning is to an appeal, you should definitely be at that hearing, because that is what the board would see and hear based on what you're saying. No new evidence may be considered during an appeal. So when submitting an appeal, you can go on our board's website, which is rcsdk12.org/suspension appeal. If you go on the website will outline what the appeal process is, and then there's a form on there that you can download. This form can also be found at the suspension school that the students end up at. Their schools themselves can also have these forms available. But what's really important about this form is that families check the reason why you're appealing? Is it because it was a procedure issue? Is it because of finding of guilt? You disagree with your child being found guilty, or the student disagree? Is it that the penalty was egregious for you? Or is it a different reason? So checking that box is really important. And then the second important thing with this form is making sure you are as detailed as possible as to why you are appealing. Again, when you appeal to the board, you won't be able to come in front of the board to explain your situation. So this is another way for you to explain, like, this is why I am appealing. And when you're ready to submit the form can be submitted either through email, fax, or dropped off at central office or mailed as well. My recommendation is to email it because it's the fastest process. And the information in terms of how to email, fax, or drop off or mail is found on our suspension appeal website. And so once the board reviews an appeal, as long as it's within the 30 school days and it's considered a long-term suspension, they have three ways they can go. They can go one of three ways. They can either uphold the superintendent's long-term decision. They can either agree with the superintendent's decision of guilt, but decide to reduce the penalty. They can reverse the superintendent's decision, and then what will happen is that families will receive a letter from our district courier that will explain to them what the board's decision is. Board staff will also do a courteous call to the families to notify them what the decision is. And then the school staff will also be notified what the board's decision was as well. And then at this point, if the families still disagree with their child long-term suspension decision, families have the right to appeal to the Commissioner of Education within 30 days as well. And so at this time, I am going to turn it over to Dr. Kathy Black, who will be talking about placement and returning to school.
And so, good evening. And so students who are placed on long-term suspension have two options currently in the district. One is to be deployed to Lynx Academy, which is our on-site program for students who are in a long-term suspension circumstance, and accommodation of instruction either at home or at a homeschool night school program. The night school program option or a home option is only exercised when students cannot be successfully deployed to Lynx together, and we have to make sure that in order to remediate, we have them in separate locations. After they serve their time, that's not the right euphemism, after students attend to their long-term suspension for whatever duration they're there, they are then returned to their schools, and return to schools includes reentry meetings. For each campus determines how the reentry meeting process goes. Depending on the infraction or the consequence and the notion to return to students, those reentry meetings can include students, parents, and members of our collaborative partners like a Pathways or our Help Zone, in addition to our social workers and counselors. And a lot of times there's a necessity for conversations between students who may have engaged in an altercation that resulted in a long-term suspension, and those end with a combination of restorative meetings and supports. We are looking at how we then provide ongoing support for students who are returning from long-term suspension, which then is the use of, again, our Pathways, our restorative partners, our SEL and emotional staff in the building. And that, I think, is our close, and I think we open up for questions. I'm looking.
Are there any questions to the Deputy Superintendent or to the General Counsel or to Charisma? Any questions? Commissioner Simmons?
Yeah, I just had a few questions. I wanted to first acknowledge, first and foremost, the state that we are in as a society. And so it does become the sober conversation between restoration of students. I'm all about restorative practice, but it also becomes that balance with accountability. You know, as a mother, you know, I often had to challenge myself if I ran into things with my son, which I did, and how I was approaching it and making sure that he was held accountable so that he learned and grew from the circumstances that he may have been in. So I think that is a balance we want to walk into these conversations with. I also want to acknowledge that we as commissioners, I'm hoping that this year we'll see a little change. I know we've had some nuances with children being, we get the suspensions in front of us, and we recognize that once the appeal happens, just depending on the time of that appeal, the child may have already been returned to school in some cases. And then also, if we choose to modify a decision around that, how are we working with the school communities to ensure that they're prepared to receive that child? So those are just some pieces I wanted to start with, and here goes the question. So starting with the classroom component, I was wondering more so about the criteria that teachers are using to determine, you know, I know there's discretion, but is there a set of criteria that determines, hey, it's time for this child to be removed? Because sometimes it can be classroom management. So I'm thinking about the coaching and classroom management, the criteria that determines, hey, it's time for you to be removed, and also how we're going about documenting that that child has now been removed, because we know that correlates to seat time. So that's my first question.
So I could begin with the answer there. So for a teacher removal, and just a teacher removal, right? Not a short-term suspension, not anything like that, right? It has to be, and I know the language is a little gray, but substantially disruptive, right? And it has to interfere with the teacher's authority over the classroom, and so that it would create disorder if the student remained in the class, right? So that is substantially disruption. Now, if the teacher decided that they would like the student to be out for a couple of classes, right, they have to complete a form of a temporary reassignment of student by the teacher, right? That's an actual formal process that they would have to go on. The principal would then look at it and then make a decision on if they were going to honor that or not. So that's for a teacher removal. If it became a serious enough event where it became a short-term suspension, in-school suspension, that they would go through a referral process. So there are two things. There's a teacher removal from the class for a couple of periods because it's causing a disruption, but only in that classroom versus did it get escalated enough where it needs to be short-term suspension, either in school or out of school.
That's helpful, because I'm also thinking if it's a repetitive piece, so maybe it doesn't turn into an in-school suspension or short-term, but the teacher may be struggling with that student and continues to put them out of class, so it falls under the radar, and it could be a classroom management or some other interventions are needed. But thank you for that, that's helpful. The other question I had, I just have two more. One around long-term, and so I'm thinking about the manifestation. I know that those pieces concern me, just making sure that we are in compliance, or oftentimes, that's been described or explained before. This is not a manifestation of the child's disability or special need. And then we talk about being in alignment with the code of conduct, which we also recognize is not being executed to fidelity. So these contradictions just kind of concern me, and I want to know what efforts we're making to get those pieces together. And then my last piece under long-term is about the supports and interventions. If a student is displaying, hey, like you said, we've tried this, we've tried that, X amount of supports have happened, are we flagging these particular students to say, hey, this is moving towards a suspension, let's get in front of this? Tell me more about that.
So if there becomes a pattern, right, and there becomes more, the code of conduct does escalate to some degree, right? So we still have to go to the code of conduct. We reinforce our code of conduct committee. We're having conversations around that, right? That is the approved board code of conduct that we must follow. As school chiefs, as administration, we make sure, and principals need to make sure the recommendations or the consequences are aligned to what is in the code of conduct, right? So that's from escalating, but you can't some things you can't escalate from a level 1 to a long-term suspension, right? You know, it depends on what that type of behavior is and what escalation it has. So those are ones, you know, there's certain that compound, others that don't, right? So you have to kind of keep that in mind. As for the manifestation, that is a process gone through with a committee of special educators to look to make sure it's not a manifestation of a disability, or if a student didn't get required services for that. And there are many that sometimes, in situations, we have to say, this is a manifestation of disability, student goes back to regular program. Right?
Yeah.
You know, so we do, that's a special educator, a committee that looks at that and makes a determination.
Yeah, for me, it becomes a compliance and just making sure we're not, you know, dancing around those pieces. And then my last thing is, I see the suspension appeal online, the form, it's really accessible and people can fill it right in. And I may have missed this, but is there this PowerPoint that was shared, you know, good information? Or do we have some outward-facing information like this that will arm parents with these type of details where they can understand, oh, this is the level, this is the tier, this is what we're looking at when it comes to suspensions, that they can just kind of click on a link?
So the code of conduct is available online, right? And we could figure out a way to make it a little bit more accessible if it's not at a point where it's easy to find. The appeals process is online as well, and then this presentation is on board docs. It is public, but if there's other ways that we need to make it more public, I'd be willing to do that.
Yeah, I was just thinking of something a little more succinct, because
Yep.
we know the code of conduct is like pages and pages long, so. But thank you so much.
Commissioner LeBron, any questions? Commissioner Patterson, do you have any questions?
No questions.
I know you just got in, Commissioner Powell, any questions? So I have a few questions here. One of the concerns that I have is that I remember in the development of the Code of Conduct, the maximum number of days that students can be out of school that we talked about was 20 days. And what I'm finding is that that is not the case, that the decision is to have our students out of the school more than the 20 days. And I plan on attending the next Code of Conduct and presenting that again to that group of people. But how do we, and there are some rationale for them being out of school, and I'm talking about for long term. And so for short term, I don't think they should be out of school no more than 5 days, because what happens to instruction? And and if they're out and not at links, let's say, and they're receiving a tutor, it has been the practice that they only get 2 hours of instruction. And so they're falling way behind. And even when they're at links, it doesn't mean that there is a continuum of learning from the classroom. And so because of that, I have issue with our students being out of school. If it's an egregious incident, 20 days, and I still have issues with that. But also, short term, it should only be 5 days. And so I guess what I'm asking is that how can we employ what the Code of Conduct says as opposed to having them to be out of school? And in some cases, we have students that are out of school 45 days. And so, you know, that too, I believe, impacts our data, our ELA and math scores. And we just have to take a holistic look at all of the decisions that we make that impact academic success. Them being out of school that long is just it's egregious. And it's kind of difficult for our students to come back, you know, and get involved in the educational community when they're that far behind. So I'm not sure who can respond to that, but I'll just pass that on to you, Dr. Peluso. How do we address that? Yeah, they're being knuckleheads. They're being, you know, they're not making the decisions that they should be making, but they're kids. They're kids, and they're growing, and they are going to make mistakes. And I do know that there are egregious mistakes, and so we cannot, to the commissioner's report, comments, Commissioner Simmons, about there does have to be accountability. But then where is the balance between accountability, and extreme punishment.
You know, I think what Council Neal said earlier about interventions, what interventions have been in play, what has happened prior, right? What is, you know, what has the supports been that would determine that? There are some egregious events, right, that are going to require a little bit more than 20 days, right? More than 20 days. But most of our events that are not egregious need to fall into that 20-day, that 20-day area from the Code of Conduct. But if they are, you know, serious enough, we need to make sure we have the supports in place prior to getting to a level that is that extreme. You know, but if we do see extreme behavior, we have to keep our buildings safe. And, you know, there are some times that we have to take actions that are going to be longer than 20 days.
Well, I would hope that those are the exceptions and not the rules. And what tends to happen in this district is that those kinds of exceptions becomes practice. And that's what we have to prevent from happening, that they don't become practice. So there has to be the kind of accountability from your staff in order to make sure that, you know, the kinds of decisions, and even from the hearing officer. Let me just say about this. We have one hearing officer who looks like, if, you know, and you all can correct me on this, but if there are 8,000 to 10,000 incidents, is she interviewing the entire 8,000 incidents that come through? So how does it work with her? And the reason I bring that up is that if she's seeing so many, if there's so many incidents, and I'm not sure of the names that are coming to her, is she doing an effective job and making the right decision? Is she taking the time to reviewing that information so that the right decision is made? And it seems as if the total decision for most of these are with her or him, whoever the hearing officer is.
So she doesn't see all suspensions. She only sees the long-term suspension. So
Okay.
anything longer than 5 days, the hearing officer will see only anything that's over 5 days, that's recommended for over 5 days.
Okay, so how many?
So that last year was approximately 350, I would say, right?
Long-term?
Long-terms, right, for the year. And actually, we saw 75 or so of those in appeals. We saw about 20% of our appeals of our long-term suspension. So those are ranging in days, right? Those are more than 5 and up to whatever it is that is recommended. The hearing officer recommends to the superintendent or their designee what her or his recommendation is. Then we confirm that. That's only a recommendation. The administration confirms the suspension decision.
Okay.
So that's the process, but the hearing officer last year saw approximately 350, give or take a few, long-term hearings.
Okay, all right. And so, but the final decision, she can make the recommendation, but the final decision, those that don't come to us for appeal as board, the superintendent or his designee makes the
They
decision.
confirm, they confirm the recommendation, make adjustments to the recommendation, and there are many that, as a designee, have looked at and said, we're going to adjust this to this number or make a change to this number. That's where the administration gets in. So there's a recommendation to administration, superintendent or their designee makes either adjustment or confirms, and that's when the decision's made.
So what happens with the short term? The short term suspensions do not come to the hearing officer.
Do not come to the hearing officer.
So they're with, the final authority is with the principal?
With the principal. Anything 5 days or less is with the final authority of the principal. And any short-term suspension appeal of a principal goes actually to the Commissioner of Education. It doesn't go to the Board of Education.
Okay, all right. And I think I had one other question. You know, we talked about developing, you know, a more effective program for alternative education. And so I'm looking forward to having conversation about what that looks like in terms of, you know, how do we return our students? How do we help them as best as we can? We're not God, so we can't, you know, we don't have, you know, his power to change, but, you know, how do we help in a way in which we're helping them to transition to the next phase of their lives, and be able to get back into the classroom so that, they can have a successful learning experience. So I'm looking forward to conversations around that and to be able to reduce the number of suspensions that we have. And I think too, when we move into, because I've always been a proponent of the middle school model, so I'm hoping that as we move forward in revising our grades, grade levels, that and that we have our 6th, 7th, and 8th graders together, that we can provide the kind of services that are going to help them transition from that kind of knucklehead phase to being more successful students. Any other questions from any of my colleagues? All right, hearing none, this particular work session is closed, but we have a motion, we have a resolution to, like a motion to amend the 2022-23 calendar for the October business meeting and moving that to October 20th. Is there a motion?
Motion.
Is there a second?
Second.
Any questions or comments relating to that motion?
Yeah, can you just for the record, why we're changing the date?
Yep, I sure can.
Thank you,
There are a
President.
number of us who are going to be at some school conferences, a school conference. Myself, the Chief Communications Officer, Commissioner Adams, and my missing someone. In any event, we're going to be, and I think that there is one of our commissioners that have another engagement, so we won't be able to have the board meeting because we won't have a quorum. And so we decided to move it to October 20th. And actually, I'm at another conference, so I won't be able to attend that date as well. I'm going to miss the Hispanic Heritage celebration, which I absolutely love. And Vice President LeBron will facilitate that meeting. So that's the reason why we are switching it, because we wouldn't have a quorum. But let me just say, I know that the meeting is in good hands with the Vice President. And to those of you who we celebrate Hispanic Heritage Month, I'm going to be missing something, so I'm pretty bummed about that. But you all will do a great job, I'm sure of that. So can I get all in favor?
Aye.
Aye.
Any opposed? Okay, so the next meeting is October 20th. The Hispanic Heritage celebration begins, I believe, at 5 o'clock. So if you all can come down can they come down in terms of COVID? Yeah, are we able to? So if you all are able to come down for that, our parents, our students, it's a great time. I always love it. Please come down and enjoy it for me. Thank you all. Motion to adjourn.
Motion.
Is there a second?
Second.
All those in favor?
Aye.
Aye.
Aye. Good night, everybody. Have a wonderful evening.